Dear friends, the latest judgment of Honorable NCLAT Principal Bench headed by Justice Ashok Bhushan in connection with Section 12A. It's a very good judgment, landmark judgment. But this judgment, is a offshoot of Baiju's case, which is continuously being argued by topmost councils of the country. Already Honorable Supreme Court dealt with that Section 12A and law is laid down. And post that judgment of Honorable Supreme Court, the NCLAT bench interpreting that law laid down by the Honorable Supreme Court approached this issue. And incidentally, there is another petition that is pending before Honorable NCLT Chennai bench. This is a complicated case. Baiju's case is going on before Honorable Justice Rakesh Kumar Jain bench. That's a Chennai bench. This is very complicated. We will discuss it a little later. Procedural issues are being under challenge. Whereas the judgment delivered in the 12A concerning the principal bench is crystal clear. Very simple, you can say. But there also there's some critical points are there which we are going to take up, analyze it. And another case is pending 12A. In this bench, Honorable Sanjeev Jain and Justice Honorable Venkatraman. And they have also still going on, but dealt with the case very well. We'll see that issues, and then we'll see whether there can be a better, because the law is not well settled saying that you do like this. No, a lot of complication is there, confusion is there. So I made 3 videos. Video 1 is about the judgment, and second is the Chennai bench judgment, and the third is Baiju's, which is going on, waiting for what is already settled. We will discuss, and how that issues have been raised on procedural conformities. In Baiju's case now, what is happening is that the IRP acted with a malified intention, and he was told to complete the process in 3 days, which he has not done. Therefore, had he done this, that 12A would have gone through. But malified intention is there. Therefore, any action done with a criminal mind will become illegal. That is going to be the judgment. We have to wait and see how the judgment develops into. So now I am taking up today this video 1. We are only talking about this judgment. What is this judgment? Before I go, I'll give a sum and substance of this case. You also note basics also need to be known. Just quickly, I'll run through basics. Suppose, for example, I lent money for interest to a company above 1 crore rupees. Or I rendered services to a company and the company has to pay me above 1 crore rupees. Or Section 10. This is, Section 7, financial creditors, Section 9, operational creditors, and Section 10 will be voluntary liquidation. So what I will do, I lent money, but then I'm not getting it. So there is a default, and then I'll file a CIR proceeding, Section 7, I will initiate, let us say. Till such time, the NCLT, the jurisdictional tribunal, decides the dispute is confined to me and the company. That's called as right in personam. Personal rights are only individually affected, so the aggrieved parties are going before the court. Then comes the next situation. The court tribunal admits the case, appoints IRP. Then, once the CIR process, corporate insolvency resolution process, is admitted, then the rights are rights in rem. That is, now everybody will, interested parties, stakeholders will come into the picture. As you know, the IRP will give advertised public announcement, and the public announcement will be calling for claims. And then the constitution of COC will come. That process you all know. But now, peculiar situations have developed that IRP is appointed, rights in rem has come. Then IRP is appointed, public announcement is given, and the promoters who gets displaced come and then try to settle the matter with that creditor, and then they settle it. Then they will inform the IRP saying that the matter is settled. That is the financial creditor aggrieved party. And then IRP is bound to apply to NCLT saying that the matter is settled. Therefore, the company can be taken out of the CIR process. It can be free. Then situation is COC is constituted. Then COC is constituted, then whether you can withdraw, yes, you can withdraw. But then there is a big process because they will become group proceedings, right in REM. And therefore, they will put a higher threshold of 90% of the COC members should agree for the withdrawal. That's also 12A petition. OTS proposal, it is also called. So withdrawal can be done even in the liquidation, because in liquidation, there is a going concern regulation 32E is there. But now we are confined to the discussion. It's a very short discussion that is settled by the Honorable NCL80. What is that? And how they have decided. Here, as I told you, one bank filed the case. CIRP is admitted. Immediately, IRP was appointed. IRP called for claims. And then many people, within 2 days, the stay order was got because the suspended board of directors ran to NCL80 and got the stay. Stay is stop the CIR proceedings since they are saying that the matter is settled between them. And it is the NCLT which has to decide. So now the question here is, the law laid down is how NCLT should adjudicate when the 12A petition is filed before it. If suppose only one-to-one dispute, no problem. And here advertisement is given and many claims were admitted. It may be a situation even before claims can be admitted, the stay order was granted. So many possible situations come. In the instant case, what happened is HDFC Bank, last day of the claims expiry, filed their claim. That means their claim is not admitted. But then the Honorable NCL80 came to the conclusion HDFC has got a right to object. And therefore, the decision taken by NCLT Allahabad bench is correct. That's all. This is what they have said. But then they have not made out any rule. How it should be handled, what are the factors to be considered. For example, when you want to extend the period of CIR process above 12.3 section, above 330 days, you have to establish exceptional circumstances, saying that the CIR process is about to be completed within 3 days, within 2 days, within 10 days. Every day you have to give reasons. But the problem with the NCLT, NCLAT is the cases will never reach. Though the timelines are important and CIR process has to be finished within a time-bound resolution, this never happens. It's because of judicial delays and all. That's a different issue. So now let us see this part alone. What is they said? What is my observation in that case? So section 12A says, withdrawal of the application admitted under section 7, 9, 10. 7 means financial creditors, 9 is operational creditors, 10 is the voluntary liquidation. The adjudicating authority may allow the withdrawal of the application admitted under section 7, 9 and 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be prescribed. That means it presupposes that COC has been constituted and the process has come and all the claimants, it will be a group proceedings. Therefore, higher threshold there. But the problem that is coming now is not after COC, before COC constitution. So the regulation 30A, has been introduced. Before constitution of the committee of creditors, this is the issue. By the applicant through the interim resolution professional. COC is not there, RP will not come. After constitution of the committee by the applicant, through the interim resolution professional, all resolution professionals as the case may be, provided this is provided that where the application is made under clause B after issue of the invitation of expression of interest under 36A, the applicant shall state the reasons justifying withdrawal after such invitation. Now, the application under Rule 1 shall be made in Form A, accompanied by bank guarantee, toward the estimated expenses incurred on or by the interim resolution professional for the purpose of Regulation 33 till the date of filing the application under Clause A of the Sub-Regulation 1. Towards the estimated expenses incurred for the purpose of clauses AA, BB, C, and D, Regulation 31, till the date of filing the application under Clause B of this. Where an application for withdrawal under Clause A, subsection 1, interim resolution shall submit the application to adjudicating authority on behalf of the applicant within 3 days. So this is where the Baiju's case is stuck up. He did not file within 3 days. And that is therefore they are trying to consider that such action is illegal. Where an application for withdrawal under clause section, clause B of section 1, the committee shall consider the application within 7 days. That is when COC is constituted. And now we can see this is the case of the decided by Honorable NCLT. Small Industrial Development Bank of India has filed an application on 7/23/20 against the corporate debtor. And then the NCLT Allahabad bench, by order that admitted the Section 7 petition application and initiated CIRP against the corporate debtor. Aditya Agarwal was appointed IRP. By order dated 15/6/22, another IRP, Anil Kumar Mittal, was appointed. That means this man is removed. On 19/6/22, IRP made a publication inviting claim for the creditors by 30th June, 19th. On 21 June, that is 2 days' time, SIDBI sent a mail to CIRP saying that they have willingness to pay and settle the full and final. We are happy. On 22, you see date 21, next date. Corporate debtor paid the amount and no objection certificate is issued. And 23, Form A was given by IRP. Based on that no objection certificate, the financial creditor. 25B, IRP on behalf of the financial creditor should be filed IA 22 12A of the code, withdrawal of the same by the company petition before NCLT. The applicant Himanshu Singh, suspended director, also filed 708 CA appeal before NCLT, challenging NCLT, challenging the order initiating the CIRP against them, which appeal was disposed of, accepting the request of the council, that is 29th applicant for withdrawal of the appeal. This tribunal also noticed that Section 12A application has already been filed by IRP. Appellate tribunal directed that till the disposal of IA under Section 12A, the implementation of the impugned order shall remain stayed. Always this happens. On 30th June 22, HDFC Bank, another financial creditor of the corporate debtor issued a claim, 4 crores. IRP, HDFC claim was not being collated by RP in view of the stay order. Now, the question is whether HDFC Bank can object. That is all. So then who all the people can object? But the NCLT did not give a proper conclusion. Para 24 of the order, you can see. We are of the view that the adjudicating authority has rightly allowed that what happened, HDFC Bank opposal has been allowed. That means that 12A withdrawal has been dismissed. The claim was filed by HDFC within the time given by IRP is a relevant factor. And any objection raised by HDFC to the 12A application cannot be said to be meritless. But for example, forget about HDFC Bank, some other person wantonly does it to put the person into trouble. And then he is not even collated. It's a safe play for him. And then based on this law, if the NCLT decides, so what will happen? The adjudicator has taken into consideration all relevant factors, including the quantum of the claim admitted and the quantum of the claim settled with SIDBI. What is that exact quantum? 400 crores to 4 crores, 4 lakhs? We don't know. Adjudicating is not mere a post office who has to allow the withdrawal filed under 12A, which is filed before the constitution of COC, which is the ratio of the judgment of Honorable Supreme Court in class trust. So now one point Honorable Supreme Court settled is adjudicating authority in earlier case, the decision of commercial wisdom by COC is not justiciable. That was from that IOP Sasidhar onwards, it's coming. But then that means mere legal procedure, something only the IA will have. But here, what is not post office? Then what he should check? Quantum, he said, how much quantum? Nothing has been properly laid down. But generally, dear friends, even if you see the regulations of IBPI, section 218, that regulations under that, if you see for investigation rules and regulations, they said very clearly this everything should be tested against the objectives of the code. When a resolution professional who is in charge of the company is acting on behalf of the company, there is no malafide intention, and then nothing causing harm to the objectives of the corporate debtor, which is maximum realization to the creditors, then there is no offense made of. See, these procedures, rules are handmade of justice. Main section is there and it's evolving law. Only the adjudicating authority in a better position. So let us see whether the honorable bench of Rakesh, the Baiju's case, Rakesh Kumar Jain sir is hearing, will be able to address this issue. Here only they said again, we however hasten to add that mere fact that the stakeholder of the corporate debtor before constitution of COC has filed an objection itself by now not be a reason for 12A application. Again they added this rider. Adjudicating authority has to advert to the irrelevant factors which may include the nature and quantum of claim of the stakeholders. In case where adjudicating authority finds that substantial and majority claim has already been settled with the corporate debtor, that may be a factor which may weigh. So substantial, this